Good afternoon and welcome to another episode of Legal Matters, where we tackle the different legal concerns of our teachers, learners, and employees with the expert advice of our Regional Legal Officer, Attorney Angelina. Good afternoon again, Attorney.
Good afternoon, ma'am, and good afternoon to all our viewers.
And this is our second episode. For our two-part episode, starting this episode, we're going to delve deeper into the DepEd Order number 49 series of 2006, or the revised rules of procedure in the Department of Education in administrative cases. So, Attorney, it means that our department, the Department of Education, we have our own system to address the possible administrative, legal, or grievances filed against our employees through the DepEd Order 49.
Yes, ma'am. Actually, with this DepEd Order number 49, series of 2006, we have set our specific guidelines on how we can address complaints filed against our personnel in the department.
Okay, and that means if we have a system, but first let's ask if this DepEd order covers all teachers, employees. Does it also cover those employees, teaching and non-teaching personnel, even in the private schools?
Ma'am, it covers those teaching and non-teaching personnel in the Department of Education, specifically for teachers, those public school teachers po.
Okay, so that means those who are working in private schools are not covered
Yes,
by this DepEd order. Okay, so that's very clear. So we mentioned a while ago that this is the system or the procedure wherein we try to address or also resolve the legal concerns filed against our personnel. So that means there are disciplining authorities, and it depends on the level of the person being complained against. So who are the disciplining authorities under this DepEd order?
Yes, ma'am, we have different disciplining authorities under DepEd Order number 49, series of 2006. So we have the Schools Division Superintendent if the person being complained of is a non-teaching personnel in the Schools Division office. But if the subject of the complaint is a teacher in the region, then it is the regional director which has jurisdiction over that person. And then, if the person also complained of is a non-teaching personnel in the regional office, it is also the regional director which has jurisdiction.
So that's very clear. Even if the teachers are assigned in schools and under the schools division offices, the regional director is the disciplining authority and not the schools division superintendent.
Yes, ma'am.
Right. In the DepEd order, if you're going to actually read it, there are more than 30 grounds for disciplinary action. But let us just tackle the most common grounds, which in your legal perspective are the most common of the legal cases that you are handling now. So what is the most common ground for disciplinary action?
Ma'am, in my over a year stay here in the regional office, I have observed that the common cases being filed involves misconduct, disgraceful and immoral conduct, what else? Insubordination, may mga ganun din po. And then, various things such as, for example, yun nga po, nabanggit mo sa disgraceful and immoral conduct because it really, kumbaga, it also appeals to me kasi nakikita ko yun almost every day.
Seemingly, it's cases. One of the, sadly, no, it's one of the top complaints no, against our personnel. So, you've mentioned about misconduct. I think I've heard there are several types of misconduct. We have simple, grave, misconduct. But first, let's define what a misconduct is and when does a proper legal or administrative case can be filed if we talk about misconduct.
Okay, ma'am. So, when we define misconduct po, it usually involves the transgression of an established rule. So, it involves an unlawful conduct of a personnel, gross neglect, what else? Corrupt acts of a personnel. Now, we have two types of misconduct. It can be grave and it can be simple. The basic definition of misconduct po kasi is a transgression of rule. But when it is already attended by the elements of corruption, willful intent to violate the law, then it becomes grave. So if it's not attended by those circumstances, it can be considered simple misconduct.
Yes, but attorney, can you give us specific examples? For example, what constitutes a simple misconduct, for example?
Simple misconduct, if let's say a teaching personnel committed a rule outside of office, outside of Department of Education, meaning it does not directly influence his acts as a teacher, meaning hindi po yun related sa functions niya masyado, then we can classify that as simple misconduct. But one thing that we have to remember po kasi, when it is misconduct, it must always be related to the performance of the duties of the teacher or the non-teaching personnel.
So, for example, you broke a rule that is being implemented in your school or in your office.
Yes.
It can be used against you
That is
administratively.
Yes.
And you've mentioned about corruption and other grounds for grave misconduct. But when can we say, for example, when can we qualify corruption or a corrupt practice, for example?
Okay, corrupt practice, for example, violations of Anti-Graft and Corrupt Practices Act. That's very common po. For teachers, usually bribery can happen. For example, someone is trying to influence you on how you will give a grade to a particular student. So that is possible po.
And I remember we talked about that in our last episode, the receiving of gifts or tokens by teachers.
Yes po.
So hopefully that will also serve as guide to our teachers so that they will not face this administrative complaints against them. So when we say, what about the other violations? Like, do we have certain policies also in DepEd aside from Anti-Graft and Corrupt Practices Act? Do we have also other policies in DepEd that we also have to take into consideration when we talk about grave misconduct?
Yes, ma'am. Based then from what I observe, usually misconduct is being prosecuted in relation to violation of no collection policy.
That is very common now.
Opo, no
Graduation
collection
time,
policy.
no? Madami tayong natatanggap ngayon.
Opo. What else? Violation of the child protection policy also when you commit maltreatment to your student, to your pupil, then it can also be classified as misconduct because you are violating a rule, which is the DepEd Child Protection Policy.
And all the other laws found in our revised penal code.
Yes, po, that's also possible.
But you've mentioned a while ago, so that is what we call the simple and grave misconduct. But there's another type of misconduct, which is, I think, hindi naman natin favorite. No, actually, we actually should condemn it as well. But this is one of the, actually being in the public assistance committee, we usually receive complaints of immorality. So this is also a ground for disciplinary action.
Yes, ma'am. Disgraceful and immoral conduct, it's also an administrative offense under DepEd Order Number 49, Series of 2006. So usually po, when we speak of disgraceful and immoral conduct, it refers to an act which violates the basic norm of decency, morality, and decorum.
So we have the CSE Memorandum Circular number 15, series of 2010.
Yes, ma'am.
To guide us as regards the different types of this misconduct. Pero under section 1 of this, we have a definition of what violates the basic decency or morality of a society. Can you elaborate on this or give us examples?
Yes, ma'am. So, when we say we are violating the basic norms of decency, usually it involves a scandalous conduct. But sometimes po, hindi naman ibig sabihin na hindi ka scandalous, hindi na yun pwedeng mag-qualify as disgraceful and immoral conduct because this admin offense can also be committed discreetly. For example, if a teacher, always example naman po, no? For example, a non-teaching personnel and then a teacher, they are both married individuals and then they decide to cohabit. And then we know that under our laws, we do not recognize that as legal. Because, syempre, alam natin, pag kasal ka, you should live with your husband or your wife. Even if those two individuals, in that example, will live discreetly, but this person who is the wife of the other individual finally files an administrative complaint, even if nililihim nila and actually walang may alam sa office ng mga yon na mayroong pagsasama na nagaganap, it is still considered as disgraceful and immoral conduct.
Okay. What if hindi po yung spouse or yung legally lawful spouse or partner yung magko-complain? It's another, for example, employee or possibly if you receive an anonymous complaint that this and this are having an affair, how do we deal with those types of complaints po?
Napakagandang question po niyan. Kasi usually they will say na, wala ka namang karapatan na mag-file ng complaint. Hindi naman ikaw yung asawa. But we have to distinguish. Kasi in criminal cases, for example, an adultery and concubinage case, you have to have the spouse to file the complaint. Because it's the choice of the spouse to decide. It's the right of the spouse to decide, whether or not to pursue the case. But in administrative cases po kasi, it is sufficient that there is a witness. Okay. So if the witness reports that to the disciplining authority and the disciplining authority obtains knowledge that there is something going on in my office, then under our DepEd Order number 49, series of 2006, the disciplining authority can actually institute the administrative complaint even by his or her own initiative.
Okay, and especially if the witness, whether anonymous or not, submits
pieces of evidence
like recordings or what, talagang magpo-proceed po yung ating...
That is possible, ma'am, as long as there is strong evidence din po to support that.
So, kailangan mag-ingat po tayong lahat, let this be a warning also to our fellow DepEd personnel. Sana po we can always live by the morals of our department as mentioned in our DepEd order. So, but alam natin, attorney, that even if we advocate for such prevention of these acts, may nangyayari pa din talaga. And what happens if a child is born out of this affair? Ano po yung magiging consequences po?
Yes, ma'am. I think I have also mentioned this in the previous episode of Legal Matters po. That in looking into an act and in considering it whether it is an immoral or disgraceful conduct, we have to look at the totality of the circumstances. So if in the case that a child was conceived out of wedlock, but the parents of the child, who are personnel of the Department of Education, have no legal impediments to marry, that's another story. Kasi pumapasok po yung immoralidad kapag hindi kayo maaring magpakasal at any time that you want. Meaning there's a legal impediment for you to
there's
get married.
There's a barrier for you in doing so.
Pero yun po, as I have said, ngayon po iba na sa panahon natin. And even the Supreme Court recognizes that na in looking into whether an act is immoral or not, you have to consider the totality of circumstances and also the prevailing norms of conduct right now.
The common question is what will be if proven guilty? Either one of the DepEd personnel is committing these acts or both of them are from DepEd. We will pause on that. Pero let's delve into other grounds for disciplinary action when we come back here at Legal Matters.
Tay, hindi ka nawawalan ng ginagawa? Naglilinis ng bahay, naghahanda ng agahan, at kung ano-ano pa. Pag nagbe-breastfeed ako kay nanay, ginagawa mo lahat para tulungan kami. Nakikita ko nga si nanay na laging nakangiti at masaya. Idol kita, tatay! Kahit nasa trabaho si nanay at si tatay, hindi ako nalulungkot. Hindi rin ako nagugutom kasi kasama kita, Lola. Bago umalis si nanay para magtrabaho, nagiiwan muna siya ng breast milk niya para maibigay mo sa akin, Lola, pag nagutom ako. Pati pagkain may nakahanda na rin. Minsan nga ikaw rin po ang nagluluto para sa akin. At syempre, naglalaro rin tayo. Lola, bukas po ulit ha. Sa araw, kahit anong oras ako magutom, umaga, tanghali, nandyan ka lagi, Nay. Kung ano ang kailangan kong kainin, inihahanda mo. Kapag gabi na at akala ko'y tulog ka na, konting iyak ko lang, gising agad. Napakasarap sa pakiramdam ng yakap mo. Idol kita, Nanay.
And we are back at Legal Matters. We're still here with Attorney Angeline Mirohel, and we're discussing about DepEd Order number 49, series of 2006. Before the commercial, we left a hanging question, ano po ba ang magiging consequence, punishment for those who will be violating the misconduct. But before we let Attorney Angeline answer that, di ba po when we enter the government service, especially nowadays, they conduct the character investigation. Yes. That's why some of those who actually qualified and are about to be appointed, pero nalaman nila that they had something in the past. What happened to these people na they're about to enter the service and they have certain legal in the past?
Yes, ma'am. Actually, this graceful and immoral conduct can also exist even prior to entering government service. I hear a lot of people say na, nangyari naman yan nung hindi pa ako teacher. Nangyari naman yan nung hindi pa ako part ng DepEd. But the point is, under our DepEd Order number 49, series of 2006, we have this administrative offense that even if you have committed that act prior to your government service, you can still be held liable for it.
And, attorney, can it be used as a ground for disqualification for the appointment if found guilty of
that's a different story, ma'am, since a pending case should not really affect your appointment or your qualification in applying for public office.
So that means that if you are applying for a position, for example, kailangan ba i-declare mo yun or let them just know about it when they conduct investigation, or paano po ba yun?
Yes, ma'am. I believe we also have the PDS. If I'm not mistaken, sa bandang likod nun, you will declare that there has been a case filed against you, what's the outcome, things like that.
So if you answer no to that question, that is another, which leads to this next. Pero kahit pahapyaw lang, attorney, let us inform our viewers that if they are found guilty of misconduct, what are the possible minimum and maximum punishments for this kinds of?
It ranges from suspension to dismissal from the service.
So pag na-dismiss sa service, it means that you will not qualify for the retirement benefits and everything.
That can be included in the findings po, in the penalty imposed. That can also be included.
So I hope that is a stern warning to all of us, not to commit immoral and other types of misconduct. It can lead to our disqualification, suspension, or even
benefits.
Yes, yung hindi natin ma-enjoy po yung ating mga benefits when we retire from the government service. And yung tanong ko kanina is, for example, you have this document, say the PDS, and you wrote something there that is not in accordance with the truth, meaning to say
you lied.
False. Yes, you lied. So that's another ground for disciplinary action, that is dishonesty.
Yes, ma'am. We also have dishonesty under our DepEd Order number 49. So, in dishonesty po, it involves the concealment or distortion of truth respecting a matter of fact related to your office or the performance of your duties as a public officer.
So, for example, it involves everything, verbal, written, basta't mayroong kang hindi sinabi na malayo sa katotohanan. Yes, okay. So, in short, tinitignan po ba sa dishonesty, what are your motivation? For example, sa pag sinabi mo na, ay kasi po hindi ko na sinabi, I did not reveal or hindi ko na po sinabi sa PSB that I have a pending case, ganyan-ganyan, kasi po baka mag-disqualify ako. So, how do we deal with those kinds of appeals po or parang reasoning po from our complainants and those that are being complained against of dishonesty?
Actually, ma'am, dishonesty is always a question of intention. So we have to look at the intention of the individual, whether he or she had bad faith at the time that he committed the distortion of truth or the concealment of facts. So we also have to look into the intention. But the hard part of this is that it's something internal. How can we ascertain? Ang next question po is, paano natin ma-ascertain yung kanyang intention? The answer there is we can always look at the overt acts of the individual. Yung mga outward actions niya, kung ano ba yung mga actions niya prior to that led to the offense.
And maybe the record of this person, kung
Yes.
parang serial na yung
Opo.
ano niya, yung paulit-ulit.
Habitual.
Yes, habitual. But yung levels of dishonesty, meron din po bang ganun na kamukha nung kanina na simple, misconduct, grave misconduct? Do we also have that type of classification for dishonesty, attorney?
Yes, ma'am. We also have serious dishonesty, less serious dishonesty, and simple dishonesty.
Also, this certain types of dishonesty corresponds to also specific punishments. Like, for example, for serious dishonesty po, what is the punishment or corresponding penalty?
Yes, ma'am. Maximum for that is dismissal po talaga. But for the three types of dishonesty, it ranges from 1 month suspension to dismissal.
So, kasama dito yung SALN din natin, no? Yung when
Yes.
we submit our sworn statement of assets, liabilities, and net worth. So,
Yes.
talagang isa rin yun. It's a public document, actually.
Yes.
Attorney.
Opo.
So, let it be also be an advocacy for us to remind all our DepEd employees here in Region 3 na seryosohin din po natin yung mga documents na ating sinasagutan, because we can be charged of dishonesty if we don't put in the correct information. Pati na rin po ba sa social media, for example, you posted something which does not have a reference or a baseless, even yung mga accusation, iba naman po yun, no? Pwede silang ma-charge ng libel or something.
Yes.
Paano po ba yung ganun sa social media, attorney?
Yes, ma'am. Depende naman po yun. Kasi if we will look into a dishonest act, we have to also consider kung na-damage ba yung government. What type of damage did it cause? Naging serious damage ba siya? Na-prejudice ba ang government sa act niya? Did he use his or her public office to commit the dishonest act? Yun po yung mga dapat nating tingnan.
Okay. Pero just to be clear with our audience, dun sa mga different types of dishonesty natin, attorney, can you give us specific examples? When do we say this type of dishonesty is serious, this is less serious, and this is simple dishonesty? Siguro, start po tayo dun sa simple dishonesty.
Opo. Possible po dyan, yung nasabi niyo po kanina sa SALN, maybe the teacher was not really aware na at that time siya ang owner ng isang property, and then hindi niya i-declare yun sa SALN niya.
Okay.
So we're going to look at we will try to ascertain the intention and the possible defenses of the individual kung bakit nagkaganon, bakit hindi niya na-i-declare. So, depende po sa magiging reason niya, kung mapatunayan naman na in good faith, and there was no really a willful intent to violate the law, then we can possibly consider it as simple.
Okay. And then, when does it become a less serious dishonesty from simple, less serious dishonesty?
Less serious when it causes less serious damage to the government, prejudice to the government. And then, pag naman yung serious dishonesty na ang pinag-uusapan, ang problema po dito is you are actually exercising you are abusing your authority. As a public official, as a public employee, government employee, you are using your position to your advantage to gain something from your position, and then you will distort the truth din po. Okay.
So, yun po yung dishonesty, no? So, you mentioned during the earlier part of our interview, one of also the most common grounds for disciplinary action is insubordination. Napaka, din to trending, di ba? Kasi pagka, for example, you don't really like your superior, o kaya the superior does not like the staff, no? Doon nasasabihin na insubordination, ganyan, no? But what really is insubordination po, attorney?
In insubordination po, we have to remember three things. The first one is that there must be a legal and lawful order. Dapat po, yung pinanggalingan ng order na yun, may legal authority. to actually mandate that or to demand that a certain thing be done. And then the second one is that yung order na yun must be coming from a superior officer, not a co-equal
Yes,
and not a co-teacher, for example. It must come from a superior. And then the third one is that your refusal must be willful and intentional. Meaning, wala ka namang valid reason for you to not follow that order, which is legal, but still you are refusing to follow it.
So, for example, our regional director issues a memorandum, and then this particular employee does not follow what is being said in that memo, pwede po siyang ma-charge ng insubordination.
Yes po, depending on the
But
circumstances.
the common insubordination complaints that we receive here in the regional office concerns our teachers asking why the school heads require them, for example, to report on a Saturday or a Sunday for this particular event. Their question is if we don't come to the school, we'll be charged of insubordination. Paano po yung mga ganun na sitwasyon wherein our teachers are being asked to report outside of the regular working hours po, which is Monday to Friday, 8 to 5.
Now, if I'm not mistaken, it's optional naman on the part of the teacher to report. And if he or she does report, there is a corresponding service credit for that. And you also check, if you are the teacher, you want to know if what is the reason ba't kami nire-require. Meron bang DepEd memo? Meron bang memo from the SDS? Then probably he or she can check on that.
Okay. So, dapat talaga may basis
Opo.
yung memorandum, no, na kapag hindi ka sumunod dun sa memo na yun, dun lang po ma-charge ng insubordination. So, all of this mentioned the grounds for disciplinary action. How do you prove the existence of this? For example, ako, anonymous complaint ako, may misconduct, ganyan. How do I prove? And how will it, how does the legal procedures of our department find someone guilty under the provisions of PO 49?
Yes, ma'am. So from your question, ma'am, I'd like to raise 2 points po, no? Yung anonymous complaints and then yung evidence required
Yes.
to find someone guilty of an administrative offense. Number 1 po, in anonymous complaints, we do not really encourage that. Kasi under DepEd Order number 49 series of 2006, we have different forms and content na required. So dapat nandun kung sino yung nagko-complain, sino yung kino-complain mo, ano ang position niya sa Department of Education, and things like that. Ang reason po kasi doon kung bakit ayaw natin as much as possible sa anonymous complaints is that gusto nating isatisfy yung due process requirement. Administrative due process requirement na dapat yung tao na inaakusahan mo, alam niya kung sino yung nag-aakusa sa kanya. So yun po yung number 1 requirement. But again, ang rule po natin, if it does not comply with the form and content, it is dismissible under our rules. But the disciplining authority, lagi pong supreme yan. So kung halimbawa meron mang anonymous report na nakarating sa kanya, and that disciplining authority has substantial evidence to believe that this is possibly happening in the ground, then he or she can initiate the case by her own initiative.
Okay. So, it means that as much as possible for a legal proceeding within our DepEd system, kailangan may formal complainant.
Yes
para
po, as
umusad
much
po
as
yung
possible.
kaso. But it doesn't mean that if these are anonymously filed by a certain complainant, it will not be addressed by our DepEd.
Ma'am, and to add to that din po, yung quantum of proof required, ito po yung dapat talaga nating tandaan. Lahat po tayo sa DepEd, ito yung dapat nating tandaan. Administrative cases are different from criminal cases and civil cases. Hindi po pare-pareho yung level ng ebidensya na kailangan para patunayan na guilty ang isang tao sa mga 3 klase ng kaso na yun. For example po, in criminal cases, dapat proof beyond reasonable doubt ang kailangan. Na 100% dapat sure tayo na itong tao na to ang gumawa ng krimen. Kasi otherwise, you will deprive the person of liberty eh. So dapat sure tayo doon 100%. On the other hand, sa civil cases naman po, preponderance of evidence lang naman. So dapat doon marami at mabigat yung ebidensya na ipepresenta mo. Ang pinaka-importante po in administrative cases is this. Kapag admin cases, dapat po nating i-emphasize talaga na ang evidence required lang dito ay substantial evidence. And what do I mean by substantial evidence? It means that evidence that will lead a person to believe that this person actually committed the offense being charged against him.
So, for example, you mentioned earlier that it is sufficient to have a witness
Yes.
for a legal case to prosper under our
Yes po.
system here in the Department of Education. So, for all our viewers, no, we tackled the three most common grounds for disciplinary action, but there are a lot more of the grounds for disciplinary action, which may be reviewed, no, under DepEd Order number 49, series of 2006. So, Attorney, we will continue our discussion next episode. But for today, what is your message for all our viewers?
Siguro po, all I can say is that time and again, as public employees, as government employees, and officials din po, we must always be guided by the proper rules of conduct pa rin po. Doon pa rin tayo bumabalik sa una nating napag-usapan na when we conduct ourselves, we should conduct ourselves in a manner beyond reproach.
Okay, very tamang-tama po yan. Thank you very much, Attorney, again for another comprehensive explanation, and indeed we learned a lot today once more, no, with your expert advice. And now that we know the different grounds for disciplinary actions under DepEd Order number 49 series of 2006, in our next episode, we shall discuss now the procedure in commencing administrative cases. So please join us again next month for another episode of Legal Matters. Good afternoon to everyone.